The Honorable Joseph Boatwright, Judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal oral argument session this morning. Let me start by introducing the judges on our panel. I am Judge Boatwright. To my right is Judge Adrian Soud, and to my left is Judge Paige Kilbane. We have two cases on the docket this morning. Each side will have 20 minutes to argue their case. The appellant is allowed time for rebuttal arguments, so when you come forward, please let us know how much time you would like for rebuttal. So the first case we have on the docket is 23-2222 Choice Towing versus TA Collections. You ready, sir? Good call.
Your Honors, may it please the court. Excuse me. Bill Gressley from Jacksonville on behalf of the appellant, who I call TTS.
How much time would you like for rebuttal?
I'm sorry,
Would you
5
like any
minutes
rebuttal?
is my aspirational goal. It never seems to work out that way, but we'll try. It's difficult to know where to start. This is actually a very simple legal question, but there's so many tentacles with bankruptcy thrown in, and the appellee has raised a number of issues which I submit are fundamentally irrelevant to the actual issue. The actual ultimate issue here is that the appellee had an opportunity in the bankruptcy court, who had exclusive jurisdiction over all these transfers that the circuit court judge below found allowed them to assert this state law claim for mere continuance based on the 4th DCA case of Dr. I can't pronounce his last name, but it's discussed at length in the brief. And in the brief, we're on day one.
You're not disputing that GT lawfully obtained a judgment against TTR originally. What you're disputing is that once the new company was formed, GT didn't have any rights to levy on anything in the new company, correct?
That's correct.
Okay.
And the reason why this is not a mere continuation claim, this went through a bankruptcy court. This is what bankruptcy courts do. The trustee in bankruptcy here asserted that the transfers to my client, in order to be not considered fraudulent as to creditors, they negotiated a deal whereby my clients assumed a whole lot of unsecured debt, additional debt. That
Was the fraudulent transfer mentioned in the actual settlement agreement? I know it was mentioned in the notice, but was it mentioned in the actual settlement agreement?
The settlement agreement specifies this all arose from the trustee's claim that this was a fraudulent transfer, and then they negotiated and reached an agreement that they had resolved that issue. And it was at that point, GT, the appellee's predecessor, had every opportunity to object to this. I mean, their theory is that once they've admitted that the trustee actually is the one who sold the assets to my client, it was not a transfer. My client could not, the TTR, the bankrupt entity, could not transfer the tow trucks to TTS because they were liened. And they went through the bankruptcy process precisely to avoid having to have these kind of issues in multiple forums or in subsequent forums. This is what bankruptcy courts do. They have, the trustee becomes the owner of all the causes of action and all the assets, and the creditors can make whatever claims they feel are warranted. The dispositive issue here is that GT, TA's predecessor, had every right to object to this compromise of the fraudulent transfer claim. And it's not...
Let's assume you're correct that that was taken care of in the bankruptcy case.
But they didn't...
So now you have this mere continuation claim. Are they the same thing?
They're both species of a fraud on creditors. It was a claim, and we've cited on page 11...
Do they derive out of the same statutory authority?
No, the process is the impleading of a fraudulent conveyance claim against a third party. And that can take the form of a fraudulent conveyance where you, and that doesn't have to be to an insider or a related entity. You could sell your assets when you're insolvent to somebody else and get cash, and creditors can object to that on the grounds that you can't transfer assets when you're insolvent. The bankruptcy judge the circuit judge here made a number of misstatements about what actually had occurred here. One was that the TTR was insolvent that selling the trucks to my client and the other assets rendered TTR insolvent. That's not correct. They were insolvent already. They were heavily indebted and underwater on all of the financing that they had. And that's why the compromise of all the trucks and the other assets that were part of the settlement agreement approved by the bankruptcy court gave GT every opportunity to say, we object to this because all you're doing is allowing a new business to take over where it's the same people running the same business. Well, legally it is not the same business. We did not take the title to any of the assets of TTR except through the bankruptcy trustee. And that's how the process works. That's why we have a bankruptcy system where claims of creditors can be sorted out. Bankruptcy trustee owns the causes of action, and GT sat silent.
Were they required to act at that point?
It's our opinion, absolutely yes. And the reason is in Justice Oaks' case, it talks at length. In that case, you shepherdized that case, and it's been cited dozens and dozens of times for what constitutes claim preclusion. GT had this claim, this mere continuation claim, arose out of the same operative facts as the fraudulent conveyance claim. And everything about this is subject to the claim preclusion analysis, which has all been met here. GT had every reason in the world to raise this issue. What they're ultimately saying is, well, TTS, my client, could buy these trucks and other assets, but they couldn't use them, or else we get to claim they're the same company. Well, that's legally nonsensical. And I direct the court to the Estate of Townsend case cited on 11 and 12 of my reply brief. That talks about the fact that you don't allow state court litigation, in that case it was probate litigation, to continue when the bankruptcy court already has jurisdiction. They have exclusive jurisdiction over these kinds of claims. And our ultimate position here is that GT had every obligation to either bring an adversarial proceeding or object to the compromise and claim. The answer brief claims that the settlement agreement was limited. There is no language of limitation whatsoever. There is no way you can read the Justice Oaks case as clarified by the Martin case and justify what the circuit judge did here. These are errors of law. The Martin case, which the appellee claims is an exception to the general rule, only explained that the statement in Justice Oaks that said that you can't enforce a settlement agreement, a bankruptcy court enters, you can't enforce that. That's taken out of context, as Martin pointed out. The state law equivalent of this is the Oliver v. Stone. I love the name of that case. Oliver v. Stone says that interim orders are all merged into the final judgment, and if you have an error that you want to bring on appeal of one of these interim orders, you have to wait until there's a final judgment. That's what the Justice Oaks case was. There was an interim order trying to approve a settlement that was challenged, and at the same time, it was the confirmation plan, which was the ultimate final order in that case, was challenged. And the 11th Circuit said, that's why the Justice Oaks case is not correct on that point. A final order, a bankruptcy court's order settling an issue is a final order. And that's what the Martin case says, and it's appealable. And so the idea that somehow settlement agreements and orders approving them in bankruptcy courts are not final and enforceable, which is the appellee's claim, is legally not correct. And you cannot read those two cases and fail to see that, and legitimately.
Were there any findings in the settlement agreement as to the fraudulent transfer issue?
That's why there was a settlement agreement, because the trustee asserted that there were fraudulent transfers, and they compromised that and got more money out of my client and got my client to take on more of the unsecured
I
debt.
understand that, but was there any actual discussion of it in the actual settlement agreement itself?
No, and there didn't have to be. It recited that the trustee had raised this issue. That's how it came about. There would have been nothing else to talk about if you had to say, well, we alleged it was a fraudulent transfer. Well, that's what the trustee's motion pointed out, that we alleged a fraudulent transfer, and we've negotiated, and this is what we're doing. And GT had every right in the world to say, we object to this, because all you're doing is using the bankruptcy court to allow new corporation to act as the old one. Well, that's what happens in bankruptcy courts. And your exclusive remedy is to tell the bankruptcy court why you think this is not correct or not fair or not legal, and it's telling and it's dispositive that GT did not do that. They sat quiet until they saw that there was some equity in the real estate that once upon a time was owed by their judgment debtor, TTR, and they said, oh, now we've got to come up with a brand new state law claim that we didn't raise in the bankruptcy. And
Did GT have any role in the settlement agreement?
they chose not to. They were noticed that the trustee was going to compromise the claim, and they set a hearing. And the standard language under the local bankruptcy rules that we cited in our briefs says, if you don't object, we assume you are okay with the relief we're asking the court for. And they sat silent. They sat silent forever until they decided that they wanted to have the stay lifted to allow them to go finish asserting their claims against TTR to the extent that it was an unsecured claim, because they couldn't assert a secured claim. And the bankruptcy court issued an order, we've cited it in the brief in the record, that says you can go get your unsecured claim. Well, what do? They turn around and got a judgment, recorded them, and acted as if it was real estate, liens on the real estate owned by TTR, which at that point TTR did not own anymore. And then claimed, well, this is just a mere continuation, so now we get to foreclose our judgment liens. Well, those are void. The bankruptcy court, the circuit court just ignored that. But more importantly, they had every reason and every right to be heard on their claim that, wait a minute, you can't use bankruptcy like this. And I submit the reason they didn't do it is because that's legally not correct. That's what bankruptcies are for. And the fact that they were owed money by someone who couldn't pay it, if this wasn't a bankruptcy case, then we'd have all kinds of different legal options available. But this whole thing was dealt with in the bankruptcy court, and GT sat silent, and it's our position that they were stuck with that. They had to accept that they still have the debt owed to them by TTR, and that my client is not a mere continuation. It's a new business which purchased its assets from the bankruptcy court.
And your position is it solely based on claim preclusion?
Yes. I mean, legally, that's the ultimate answer here, is even forgetting all of the other things, which is this is not a mere continuation. This is a new entity.
And it's not a mere continuation because they purchase assets from the trustee, because otherwise,
Yes. You
it's
could
clearly
make
the same
claim, but
business,
It's
it
not,
seems.
they're not identical. They lost, 60% of their business by filing bankruptcy, and they lost at least one employee. I can't remember. There were some differences, but yes, you had all these similarities, and this has been transparent. That's what happened when you file bankruptcy.
Right, but you don't, for claim preclusion is a very specific doctrine,
That's
right?
correct. Yes, ma'am.
So,
Same operative facts.
okay, well, that's not the only factor, though, right? There are other things to look at.
Sure, but the other
elements of
ones
the
are-
claims and all of that. And fraudulent transfer, you don't have to have a fraud necessarily to have a mere continuation, do you?
Well, why would it ever come up? It is a fraud on creditors. If all you're doing is putting a different name on the door and doing exactly the same thing, which is the doctor case from the 4th DCA, which we cited, they used everything. All they did was change the name on the door. Well, that's not what happened here. Yes, you have plenty of indications that, yes, it's the same business. My client's representative, Nicole Bostwick, said, we did this so I could continue in the towing business. But they did it through the bankruptcy court, and that's the dispositive point, is that the GT had every chance to raise this issue and have it adjudicated, and it ultimately came down to a claim.
Any relevance to your argument that the trial court makes a point that this debt was not even discharged because it was a Chapter 7? Does that even have any relevance to the
It
argument?
has
you're
no
making?
relevance because Chapter 7 with a corporation is a liquidation. There are no discharges in that case, and that's black letter bankruptcy law. And so the confusion here is,
But they had filed a Chapter 7, correct? TTR had?
yes.
Okay.
Yes, it was a liquidation, and they have nothing left, which is why they've come up with this novel, entertaining and creative theory that lacks a legal basis. I'd like, if I could, for the first time maybe in my entire career, to save 6 minutes or 5:55 or whatever. Thank you.
Good morning, Your Honors. Good morning. May it please the Court, I'm Eric Kohler representing TA Collections, who's the assignee of the GT Leasing, who was involved prior with the appellant. I think the key legal concept here is there's a distinct claim between the mere continuation, de facto merger, alter ego, is a completely different claim than fraudulent transfer. And as you stated, what is going on here is that
Can that type of claim be settled in a bankruptcy proceeding?
No, it can't. And if you look at the Florida case of Seminole Boatyard versus Christoph, that case out of the 4th DCA specifically holds that a bankruptcy trustee does not have any standing to assert an alter ego claim. And in fact, no alter ego claim was asserted by the bankruptcy court.
Is a fraudulent transfer claim and an alter ego claim one and the same?
No. And so
What's the major difference?
the major difference is there's no element of intent. There's no requirement of fraudulent intent for an alter ego claim. Furthermore, when you talk about an alter ego mere continuation claim, they're looking at
Are the remedies the same? Are the remedies the same? How you can
No.
seize assets? Are they different?
Right. So in a fraudulent transfer claim, the trustee, and if you look at the notice of intent, the trustee is saying, right before, what happened in this case is that on November 4th, right before a trial, the appellant got together with a couple of attorneys and transferred all their assets over to a new company, formed a new company. And then the next day, then they had TTR, the old company, file bankruptcy.
And that was on the eve of trial, correct? Or a couple
Well, it
of
was
days
3
before
weeks
trial?
before the trial.
Okay.
So the trustee said, well, wait, all these assets were gone now from this company that filed bankruptcy. We want those assets back, okay? So they were saying, well, the assets weren't really worth anything. We'll settle. And also, the bank had a big lien on all the assets. So the appellant was saying at that point, well, the assets aren't worth anything. The bank has a lien. And so the trustee said, well, we'll give some money to the bank, we'll take some money, and we'll settle our claim against to get back these assets. A mere continuation alter ego claim says that the new company is liable for the old company's debts, okay? So that's a completely different remedy. Does that answer your question? Okay. So again, another difference is that when you look at an alter ego mere continuation claim, what they're looking at, and if you look at the Munum case, they're talking about the bottom line question is whether each entity has run its own race or whether there has been a relay-style passing of the baton from one to the other. And they look at, are the same services being provided with the same files, patients, employees, et cetera, okay? And then in this case also, the alter ego claim is looking at what happened after the transfer of assets. So they look at what happened, what was the corporation doing, okay? And in this case, the judge says there was the same stockholder. It says there was the same level of income from 2009 to 2014. Of course, the bankruptcy happened in 2011. Both businesses were known as this fictitious name, Troy's Towing, Troyz Towing. And Troy Bostic was the husband of the stockholder, okay? He was the guy who was going out on the towing runs. That name was put on the tow trucks both years afterwards and before. And then in 2002, Troy Bostic came into his deposition, he said, yeah, I've been working for the same company for 28 years. All we do is tow trucks, we do the same thing we've been doing for 28 years. In 2022, the new company, TTS, said, hey, we've been doing business for 20 years. So if TTS only was formed in 2011, that would only go back 11 years. So if they're saying they did business for 20 years, 9 of those years must have been when they were doing business as TTR, the old company. So the judge took all those into consideration and said, hey, yeah, this company is the same thing as the old company. You see what I'm saying? I mean, they have the same employees, they're advertising the same, everything else. Those are all material differences in the causes of action that were asserted here. And again, what happened here is there's several types of bankruptcy, and usually when you think about a bankruptcy, you think about you're getting a discharge. In a corporate Chapter 7 bankruptcy, there is no discharge. And if you look at the cases, there's plenty of cases in this they're doing the same thing. I mean, this is not a novel type case that we're doing. The law is set out in the National Labor Relations Board, the Better Building Supply Corp. It says that partnerships and corporations may not discharge their debts in a liquidation proceeding under Chapter 7. In adopting Section 727A, Congress intended that corporate debt would survive Chapter 7 proceedings and be charged against the corporation when it resumed operations. So it's the same thing we're doing here. What they were trying to do is, there is a provision under Chapter 11 where you can get a discharge, but it's expensive to do that, and it's cumbersome to do that for a corporation. So what they did is they did a cheap Chapter 7 case, hoping that this would all go away, but it didn't. So, and if you look at particularly Seminole Boatyard is very interesting too, because that's a Florida case. In this case, Seminole Boatyard leased property to another company, FAM. There's a guy named Christoph who is the president of FAM. There was litigation. Seminole recovered a judgment for rent against FAM. FAM then filed a Chapter 7 bankruptcy, just like we have today. Christoph goes to the Chapter 7 trustee and he says, hey, I'll tell you what, I'll pay you $50,000, or I think it was $55,000, for a full release of all claims that the company may have against me, okay? And so the trustee said, okay, we're releasing you, Christoph, from any claims at all, any potential claims that the trustee has. The creditor, Seminole Boatyard, keeps going, pursues an alter ego claim against Christoph. The trial court says, no, you can't do that. There was a release. You didn't object to all that stuff. You could have gone and paid more for that and gotten the release yourself, but you didn't. So you're done. You're out. The fourth DCA reverses. It says, wait a second. Seminole Boatyard is pursuing an alter ego claim. The trustee could never pursue that. It didn't have standing to pursue it. And it's kind of a weird legal concept that in order to have an alter ego mere continuation case, it has to be brought by a creditor. The company can't do that. If there was a fraudulent transfer case, the company could do that. That is, if you had Coca-Cola and their directors spun off something illegally, the shareholders of Coca-Cola could say, I want that back, okay? That's a fraudulent transfer. That can't happen with an alter ego claim. And then if you look at there's other cases such as Izzo Golf. We went through that. Izzo Golf is very interesting as well. It's the same thing. There was a big trademark infringement case. There was a judgment for $12 million. The company filed Chapter 7 bankruptcy. There was also an alter ego claim going on at that time. The King Park trustee filed a fraudulent transfer adversary proceeding, which is like a separate lawsuit. And it said, well, we're seeking those assets back. If you look at the case, it's very interesting. The trustee also filed an alter ego claim, but then the trustee realized, and the court realized, in that bankruptcy case, the trustee couldn't pursue an alter ego claim. So they dismissed the alter ego claim. So in that case, there was, similar to this case, there was a notice of compromise. Baird paid money to the bankruptcy case, to the bankruptcy trustee, paid $1.9 million. Izzo filed proof of claim, participated in the bankruptcy case, got some of that $1.9 million to pay part of its claim. Izzo then got relief from the automatic stay, which is what we did, and then they filed an alter ego claim, or continued the alter ego claim against Baird, the shareholder. Okay? The court said, yeah, you get an alter ego claim. There's nothing wrong with that. It cites several cases, and we went through those in our brief: Goodman, NLRB, Jackson versus Corporate Gear, Custom Builders of Steamboat, Inc., that all you say, yes, you can do this. I mean, so there's a legion of cases that say you can pursue an alter ego case. A couple other cases, the Jackson versus Corporate Gear case that we cited too says that once the bankruptcy is over, there's no reason for the judgment debtor not to go ahead and collect its judgment, and that's what we're doing. I don't think there's no dispute that we do have a judgment. It continues after the bankruptcy. And then Justice Oaks, the Martin case is a little hard to deal. It could be a little hard to understand. Justice Oaks was the big 11th Circuit case. It's cited all the time. And what it says is, if you have a compromise, it can never have preclusive effect. It can never be a final judgment. And that is because you have to have four things to have a claim preclusion. You have to have a court of competent jurisdiction, a final judgment, has to be the same parties, and it has to be the same claims, causes of action. And so Justice Oaks says, what is going on when the court approves a bankruptcy settlement is that the court just says, hey, is this in the best interest of the estate? And it considers the chances of success, the expenses that the trustee is going to have to incur to go after somebody, the length of time, things like that. So that's all it's determining. So again, that is not the same claim we're talking about as to whether an alter ego exists. That is, whether the company is the same company, whether it ran its own race, okay? And if you look at, there's the case that we cited, HDR Architecture, is also a bankruptcy case. HDR Architecture says, just because there's a settlement between two different parties, the trustee and another party, because there's a third party that is a part of the bankruptcy and doesn't object to that settlement, that doesn't make them part of the settlement. So that is, GT is not a party to that settlement with the trustee right under HDR Architecture. That's the case that says that. You already asked, I think maybe Judge Copain asked that. There is a narrow exception in Martin v. Pathos, which is a case where the debtor was getting sued. There was a judgment against the debtor. The debtor then came in and said, I want to undo the judgment because I wasn't properly served. He filed bankruptcy, okay? The trustee comes in and says, I want to settle this thing. Mr. Creditor, look, you give me some money and we'll agree this case is over. There's a possibility of upsetting your judgment, but you give us this money, we'll settle the case. They go to the judge, the bankruptcy judge. The judge says, yes, I approve settling this particular case for this much money. That case is over. The bankruptcy trustee can take the money. After the bankruptcy, the debtor comes back and says, well, wait a second, I want to relitigate that case because I was never served. So I want to get back all this money from the creditor. And the judge says, wait a second, you can't do that. That is the same parties, the same issues. The same issues where he's trying to relitigate the defense of improper service of process. And that's the same thing that the trustee gave up, okay? And so it's the same parties, it's the debtor. The trustee stepped in the shoes of the debtor. So in that case, it's a narrow exception to the Justice Oaks rule about this never claim preclusion. Let's talk about our fee. We would also we're asking for affirmance of the judgment. And I will like you, if you look at the judgment, I think Judge Dees did a really good job. It's a 28-page judgment. He spent about 6 or 7 months debating this thing because there's a lot of crazy things going on. But he did find that we're entitled to attorney's fees and costs under 5629. There was a supplemental judgment for fees that was issued. And in that case, the judge finds that we're entitled to fees under both 5629 and the lease between GT and the appellant, which was assigned to my client, that master lease agreement provides for prevailing party attorney's fees as well as fees on appeal. So we're asking for affirmance of the fee judgment as well as we're asking for fees on appeal. There's a couple things in the appellant's reply brief there were two cases that he talked about under Prayer. He's saying, well, Prayer says that you can only get a continuation judgment if it's an employment litigation case. What Prayer actually says, it says, well, there's a general rule of non-successful liability if a company, takes over the assets of another company. It says, one exception is if there's an employee that has a claim against the prior company. Prayer doesn't say that only, labor relations or employee cases involving Chapter 7 businesses can result in a judgment after the bankruptcy. And certainly Izzo and Seminole Boatyard and the other cases that we cited are involving cases other than employment litigation. Also, the reply brief talks about Molinos, which is another 11th Circuit case distinguishing Seminole Boatyard, but that case, it doesn't involve a bankruptcy, it's not on point. It just says that you have to, in order to pursue an alter ego claim, you have to go after a shareholder of the company. Okay, so it doesn't talk about a bankruptcy or anything like that. And I think that the key thing that if you look at the appellant's brief, they're trying to say, well, the trustee, he said on page 9 of the reply brief, the trustee had full authority to bring an alter ego claim. There's no way that could happen. If you look at Seminole Boatyard says 180-degree opposite. It says the trustee could never bring an alter ego claim. So I just think for all those reasons, the court should affirm. Is there any questions I can answer?
Thank you.
Thank you.
Where to start? I disagree with all of the legal points that Mr. Kohler has made, which will not surprise you. Let's deal with the Seminole Boatyard case first because he places great reliance on that. 10 and 11 in the reply brief discusses it in detail. That turned on whether a debtor corporation could attempt to pierce its own corporate veil and sue its controlling shareholder. That has nothing to do with this case, which is the trustee's sale approved by the bankruptcy court of the sale of the debtor's assets to my client. In the Lama case out of the 11th Circuit,
I think what he was arguing with that case is saying that the alter ego could only be, or the alter ego claim could only be brought in state court, not in bankruptcy court. Does that case say that?
it does not. And what the 11th Circuit in Lama, doing a survey of Florida law, this is on 10 and 11 of the reply brief, that if Florida law, and I'm quoting, if Florida law allowed such a claim, it was part of the debtor's bankruptcy estate. And because the Fourth Circuit did not specify whether the target of this piercing was even a shareholder, the 11th Circuit said even if this individual did not own stock, which you couldn't tell from the Boatyard opinion, this would cause the Florida Supreme Court to pay this precedent little heed. So that's an outlier case, factually distinguishable and legally not relevant to this case. The question that keeps coming, or the argument is an alter ego is not the same as a fraudulent transfer. No, but they both come out of the same operative facts, and that's what the claim preclusion and res judicata analysis points out. I urge this court, and I know you will have looked at this and will again, the Justice Oaks case and the Martin case, when read together, are clear that all that Justice Oaks dealt with it saying that a settlement agreement is not enforceable is because it was an interim agreement in a Chapter 11 where you had a comprehensive plan which acted as the truly final judgment in the bankruptcy. And that subsumed the interim order, that the settlement agreement that the Wallaces in that case tried to appeal. The Martin case makes clear that it's indisputable that the causes of action involved in Martin are identical since both cases arise from the same nucleus of operative facts and involve the same factual predicates. That's exactly what the alter ego mere continuation claim is. Oh, you've got all the same assets and you're doing the same business. Well, it's not exactly the same. There's plenty of overlap, no question about it, but it was done through the bankruptcy for the reason that that's how you get to keep working on some level and have a trustee who's the fraudulent transfer expert who raised that issue, said this is a fraudulent transfer, you have to do more. and approved it, and the bankruptcy judge signed off on it.
But counsel, and I go back to, you keep referencing the same operative facts. I don't dispute that, but I guess my concern is that doesn't necessarily mean that it's the same cause of action for purposes of res judicata or claim preclusion. Those are both very specific doctrines that are reliant on several factors, and same operative facts does not encompass all those things. Essentially, that just means they need to be brought together, but it could be multiple causes of action arising from those operative facts.
That's why the doctrine says that governs claims that were made or could have been made. And I fundamentally disagree with Mr. Kohler when he said that this mere continuation could not have been brought in the bankruptcy. That's absolutely incorrect. This situation where my client is continuing to do business as a towing company with their name in it, that existed at the time of the bankruptcy. They had years to bring this claim in the bankruptcy court, and they didn't. They didn't do it until they smelled the possibility of doing this new cause of action that they couldn't have raised before. I think it's 7 years after the fact. So, thank you, Your Honors. I rest on my on the brief on the other issues that were raised. Thank you so much.
Thank you. Very
Thank
well
you.
argued case. Thank you.